Welcome to the first class of AK classes. Since today is the first class, so I will give a brief introduction of Constitution. So what is Constitution? But before giving brief introduction to Constitution, I would like to suggest all the students to follow only one book, and as I'm showing in the video, I'm following Constitutional Law of India, written by Narendra Kumar by Allahabad Law Agency, and it is the best book according to me. So you can also follow this books for Constitutional Law of India. So what is Constitution? A constitution may be briefly defined as a document having a special legal sanctity which sets out the framework and the principal functions of the organs of the government of a state and declares the principles governing the operation of those organs. It is the basic or fundamental document of a society or a country and contains the basic fundamental first law of the country. This document is also known as the Grundnorm of the country. Now coming to the second part, what are the organs of the government? So there are basically three organs of the government. So I would like to explain by writing. So number one is legislature. Number two is executive. Number three is judiciary. Now, number one, legislature. What is the function of the legislature? It generally makes laws. Amend them or repeal them. Number two, executive. Executive function is to execute or administers the law. Executes or administers the laws. And judiciary function is to interpret the laws. Interpret the laws. So in short, legislature makes laws, amend them or repeal them. Executive executes or administers the laws, and judiciary, its function is to interpret the laws. So these are the three main organs of the government. Three main organs of the government. Now coming to the classification of constitutions. Constitution may be number one, written or unwritten, number two, unitary or federal, and number three, flexible or rigid. So coming to the first part, constitution may be written or unwritten. A written constitution is one which is written down in the form of a document. It is a single source of all constitutional law of the country. As a consequence, it lays down a limited or a controlled government, in the sense that every organ of the government must act in accordance with the constitution and within the limitations prescribed by it. And number two is what? A constitution can also be unwritten if it is not embodied in one of the comprehensive document. For example, the Constitution of Great Britain, it is unwritten. Then coming to the second part, constitution. Number two, constitution may be unitary or federal. What is a unitary form of constitution? It has only one set of government, and it is the central government. It is with the central government in which all powers of the government are concentrated. The unit governments under such a constitution operate as subordinates to the central government. And a constitution, second type is a constitution can be federal if it provides for the division of powers between the central government and the state government, that is unit governments. Then coming to the third type, constitution may be flexible or rigid. A constitution is known as flexible if it provides a simple procedure for its amendment as is prescribed for making laws. And a rigid constitution is one which provides a special, complex and more technical procedure for its amendment. Now, a constitution, is it a living document? Yes, a constitution is a living document. A constitution is said to be a living and organic document which of all instruments has the greatest claim to be construed broadly and liberally. Being a living organ, it is ongoing, and with the passage of time, law must be changing. So horizons of constitutional law, it is said, are expanding. It is required to be kept young, energetic and alive. What is constitutional law? Constitutional law is defined as the rules which constitutional law is defined as the rules which regulate the structure of the organs of the government of a state and their relationship to each other and determine their principal functions. Now coming to the main part, what are the forms of government? One is parliamentary form of government. What is the parliamentary form of government? The head of the state is merely a constitutional head. Number 2, the council of ministers vested with real and effective powers is made answerable to the legislature. Number 3, the council of ministers, which is the real executive, consists of the members of the legislature belonging to the party in power, having support of the majority in the legislature. Number 4, the Prime Minister, who is the head of the Council of Ministers, occupies a dominant position having absolute direction in appointing and dismissing the ministers and allocating the government business among them. Number 5, since the Council of Ministers is answerable to the legislature, its tenure is dependent on the will of the legislature. The ministers are collectively responsible to the legislature, and on the defeat of the government on a policy matter in the legislature, it leads to the resignation of the whole Council of Ministers. Now coming to the second type of government, it is presidential system of government, and it is one of the important system of government. Now under the presidential system of government, the president, the chief executive, is the real executive head of the government. Number 2, the president enjoys full discretion in selecting the members of his cabinet. Number 3, under the presidential system, the president cannot be removed by a vote of no confidence in parliament. Number 4, under such a system, the legislature cannot dictate to the president. And number 5, the president under such a system is not responsible as far as initiation of legislation is concerned. Now, what are the merits of presidential system? It enables the president to have best outstanding persons of competence and integrity as ministers. Number 2, since the ministers are not elected, they are not motivated to adopt cheap populist measures. Number 3, the ministers devote their time for development instead of wasting their time and potential in endless politicking. It ensures discipline among the party's members and stops defections or desertions for thirst of power and hunger for office. So, something to know about Indian parliamentary system. Now, India adopted the parliamentary system mainly because the country had grown familiar with this system during the British regime. It had drawn upon the traditions of the British constitutional law. Secondly, this system ensures harmony between the executive and the legislature. Thirdly, it gives more responsibility, daily as well as periodic. Now, the multiplicity of political parties, evil of defections, lack of cohesiveness and leadership in national parties, illiteracy of voters, large growth of regional parties, espousing the cause of local issues rather than national issues, criminalization of politics are some of these why India has adopted Indian parliamentary system. So for today, this much is enough, and don't forget to like, share and subscribe my channel. Thank you.